But just before we continue, let me remind viewers at home again that to be part of the program, just tweet at us using the hashtag Saraki debacle.
When Saraki committed those offenses 6, 7, 8 years, 9, 10 years ago, whatever time it is, there is no law, as far as I do know, that says that there can't be retroactive justice or retroactive trial. It doesn't matter when you commit an offense. What matters most is when you have a responsible government that can take the bull by the horn and do what is right. And that's what the PDP didn't do for 16 years. But I don't want to go into that politics. I'm not a member of the APC. Neither am I a member of the PDP. My argument is this. First, mentioned that there is a standing order from the High Court which bars the CCT from going on with the trial. That is totally false. What the judgment, or perhaps the verdict says, is that the CCT and Saraki et al. Should appear before it on Monday and show cause, mark my words, show cause why the ex parte motion should not be granted. So in this case, there is no ex parte motion on grant. It's just show cause. And it was on Friday that CCT expected the Saraki to appear, and Saraki didn't. That's point number one. Point number two, the judge also mentioned something, that Saraki is being haunted because Wari et al. Knows so well that Saraki can be stampeded. As far as I am concerned, as a political scientist, there's no difference between a Saraki when he was in PDP and a Saraki when he was now that he's in the APC. Plus all the members who defected alongside both parties. As a matter of fact, there is no geographical difference between the PDP and the APC. What you have are just a few individuals who are better off. So let us take the argument completely away from PDP APC alignment.
Senator Bukola Saraki, the Senate President, has said that he's willing to submit himself to due process and the law, and that this issue concerning him, the reason why he went to approach the Federal High Court was because of the way that the charges were filed. There is a stipulated law on how these charges can be filed. I've already raised those issues earlier, and that the reason why he went to approach the court was because the right thing was not done. Like I said earlier, you cannot build something on nothing. And it is it is extremely clear that he said that he resorted to go to the Federal High Court for the determination of the issues of competence of the prosecutor, as well as the compliance with the procedure stipulated in the Code of Conduct Bureau and the Tribunal Act. That is the reason why Senator Bukola Saraki has approached the Federal High Court. It is very clear that every time we make issues or arguments, we should argue based on the facts of the matter.
I think there is more to what we see on the pages of newspapers than what is happening currently inside there. Because ever since he picked up the job as the Senate President, he's been battling with one case or the other. First of all, there was a warning letter sent to him in guise of calling his wife to the EFCC. I mean, inviting his wife to the EFCC was a warning letter to him. I mean, you should check your back, and now they've come for him. And certainly, I think Saraki is not the only person violating that law, if indeed he has, because we have other governors, other former governors, senators, House of Rep members who also violated that law. But I think in Saraki's case, now I think it's a kind of witch hunt for me. I would think the witch hunt for him because ever since he has accepted that job to be the Senate President, and looking at the controversies that shaded everything, he has been on one point or the other calling him. People have been calling him for resignation simply because he was the Senate President and was not the real person who the APC wanted to be there. So they are using every means.
There is nothing like an injunction on ground. I'd said that earlier. Point number two, they also mentioned that APC or the Buhari-led government is trying to build something on nothing. That is also a fallacy, because in this case, the Attorney General of the Federation is not an office. That's quite right. There is an office called the Solicitor General of the Federation. He needs to go check the laws. He knows what I'm talking about. The laws are there. The Solicitor General of the Federation, under Nigeria's 1999 Constitution, can initiate certain proceedings, particularly when it has to do with the Code of Conduct Tribunal. That law is there. It's not a matter of argument. He knows, and he needs to double check that fact. So this whole question of this allegation is coming on a platform of nothing does not suffice. And then lastly, when you talk about Dr. Saraki going to court to protect or enforce his fundamental rights, he is the one who is bringing something on nothing, or nothing on nothing, if you like, because in this case, no right has been breached.
Known as the Lawyers Act, there's there's a section that says additional powers and duties of the Solicitor General of the Federation. The Solicitor General of the Federation, in the absence of the Attorney General of the Federation, may perform any of the duties and shall have the same powers as imposed by law on the Attorney General of the Federation. Now, the reason why I'm actually trying to state this here clearly is because he has been hammering that Saraki refused to attend because the way the process was initiated was incorrect. Now, if you look at it, one of the things he mentioned in his submission to the Federal High Court was that there's no Attorney General to the Federation in place, so you cannot bring a case, or you can't bring him to the CCT, and that is not correct. His lawyers even know this too. So why are they just discussing around with him? They probably have their own aims that actually want to achieve with this delay. So I think people should actually know that certain laws, there's even a Supreme Court ruling some years back that actually elaborated or shed more light on this. It was in the case of the Attorney General of the Federation versus the MPP, reported in Part 851 of the Nigerian Weekly Law Report.
The case he filed in the Federal High Court is simple. He is about issue of competence, and it's about issue of how the cases were filed. In 2011, when Asiwaju Bola Ahmed Tinubu was charged to court, the present Vice President and Olanekpe and others, they went to the Federal High Court. They did this same thing. So what are we talking about? We keep making issues out of nothing. A man has the right to go to the Federal High Court to challenge any issue that he feels infringes on his right. Senator Bukola Saraki said he's willing to face, he's willing to abide by the law, he's willing to go to court, he's willing to go to full trial with the CCT, but the reason why he's approaching the Federal High Court is because of so-so and so-so, for so-so reasons. And he has stated them very clearly. So I don't see why people will come and be saying that Senator Saraki has no right to go to the Federal High Court. And people will now go ahead to commend the arrest warrant that was issued to contravene the order of the High Court. It doesn't make any sense to me.
All right, guys, thank you for coming this afternoon on the program and sharing your thoughts. But that's how we have to hold it on this segment of the program. We'll take a break, and when we return, we'll be joined by a legal practitioner, Temitope Atiba. Please stay with us.